Grenada's Prime Minister Dickon Mitchell, who himself is a lawyer, has responded to the dismissal by the Caribbean Court of Justice of a lawsuit brought against the Trinidad and Tobago government over the 2009 collapse of the British American Insurance Company Limited, Baico. A regional policyholders group known as Baico brought the lawsuit for policyholders in Antigua and Barbuda, Dominica, Grenada, Montserrat, St. Kitts and Nevis, St. Lucia, and St. Vincent and the Grenadines. Baico said the collapse of Baico resulted in losses of over $800 million to businesses and individuals. The lawyers for the policyholders argued that the Trinidad and Tobago government breached the revised Treaty of Chaguaramas, which established the CARICOM single market and economy, by bailing out certain local CL financial subsidiaries, such as CLECO and Britain American Trinidad, and not regional subsidiaries such as Baico. In an exclusive interview with Prime Minister Dickon Mitchell, which is to be aired next Tuesday on WPG10 TV, the Grenadian leader was asked about the ruling by Calistra Farrier.
Prime Minister, we're almost out of time, I know, but I really wanted to. The Caribbean Court of Justice has just delivered its ruling on the matter that was brought by policyholders in Grenada and Antigua from the British American fiasco a few years ago. And the CCJ has ruled in favor of Trinidad, the government of Trinidad and Tobago. The basis for this had to do with the revised Treaty of Chaguaramas and so on. What is your take on how this all played out? Because the citizens were unable to find a remedy within the treaty.
Yes, and in a sense, the case was novel. I think we knew it was always going to be a difficult case to win. And I've read the summary of the reasons for the judgment, not the entire very lengthy judgment, but in essence, my understanding of the reason is that they're saying the decisions taken by Trinidad and Tobago in relation to CLECO in particular, and in relation to the citizens of Trinidad and Tobago, could only apply to Trinidad and Tobago, because if not, it will mean Trinidad and Tobago exercising extraterritorial or extrajudicial powers outside of Trinidad and Tobago, and that the government of Trinidad and Tobago doesn't rule Grenada, for example, or doesn't rule St. Lucia or Barbados, and that Baico itself was not incorporated in Trinidad and Tobago. It was not a Trinidad entity, even though its parent company, CLECO, might have been a parent, might have been a Trinidad company. So Baico, I think at the time, was actually incorporated in the Bahamas, operating in several of the jurisdictions. So I understand the legal reasoning, but obviously, as policymakers in the region, it means we really do have to look at how do we protect our citizens of the region, where you have an entity that might be registered or formed in one jurisdiction, but obviously operating as a multi-jurisdictional or multinational corporation. And how do we ensure that, because in effect, Trinidad and Tobago took decisions to protect the economy of Trinidad and Tobago and to protect the citizens of Trinidad and Tobago. The case that was made essentially, by doing so, they're saying they were discriminating against Grenadians or Antiguans, because effectively that protection did not extend to them, even though they were policyholders of Baico. And the court's ruling is that they could not do so based on the actions they took, because it will mean effectively doing things in Grenada or doing things in Antigua, which the Trinidad and Tobago government simply doesn't have the legal power or capacity to do. So it does mean that from that sense, redress is not available to the policyholders from that perspective. But I think from the perspective of Antigua and Grenada and the OECS, we are going to have to relook this and see what, if anything, can be done to help support some of these policyholders who obviously lost millions, because it's institutional policyholders as well as individuals. NIS, Grenada Cooperative Nutmeg Association, and a lot of individual persons who lost millions and millions of dollars in this field.
So as a lawyer, you're saying that there are no more legal moves to make?
Well, there's no further appeal from the CCJ itself, because it's basically it has original appellate jurisdiction on interpreting the treaty and the obligations of the treaty between member states.
So any ideas have flashed through your mind about how these policyholders can be helped? A lot of people suffered and ended in poverty because of this.
No, I think we are going to have to look at if there are any assets of Baico that is available or left in our jurisdiction. Remember, Baico is under judicial management as well, to see whether there's anything left from those assets and to see whether or not they can be sold and or applied. But obviously, they're under judicial management. I can't currently speak to the current state of the judicial management winding up liquidation process, because I have not been briefed on it. So I think it's only after that happens we'll be in a position to know if any redress can be provided or any measure of assistance can be provided to them.